Welcome to the Deep Dive. Today we're asking, when do you really need an eviction lawyer? Especially if you're a renter here in California.
It's a critical question. Eviction, or unlawful detainer, as it's legally called, is a serious process, and knowing when to get legal help can make all the difference for a tenant.
Right. We've synthesized a lot of information on California eviction law and tenant rights for this.
And our mission today is pretty straightforward. Clearly outline those key moments when a tenant facing eviction absolutely should seek legal help to protect their rights.
And we want to mention the Martinez Law Center based in Santa Ana. They specialize in unlawful detainer cases, but importantly, they only represent tenants, never landlords.
That's right. They focus on tenants in Orange County, Riverside, San Diego, and LA County, handling eviction defense and some related issues. Their website is martinezlawcenter.com.
Okay, so let's dive in. You're a tenant, you get some kind of notice from your landlord, maybe a 3-day notice. When does that piece of paper become an emergency?
Pretty much immediately. The moment you receive any official notice or court paperwork about eviction, you need to pay attention. This unlawful detainer process moves incredibly fast.
Fast how? Like, what kind of time frame are we talking about?
Well, that initial notice might give you just 3 days, but if a lawsuit is actually filed, you typically have only 5 calendar days to file a formal response with the court.
5 days? Wow. Okay, and what's that response called?
It's usually called an answer, and there's a specific court form, UD 105.
And if you don't file it, if you miss that 5-day window?
That's the danger zone. The landlord can ask for and likely get a default judgment, meaning you lose automatically. You could be evicted without ever presenting your side in court.
So getting a lawyer involved right at that notice stage sounds, well, crucial.
It really is. A lawyer can help you understand the notice, make sure the right forms like the answer are filled out correctly, and, most importantly, filed on time.
Okay, so that's the initial notice. What if things escalate and you actually get served with an unlawful detainer lawsuit?
Now it's definitely serious. It's a formal civil lawsuit. You need a legal defense. And unlike criminal cases, the court won't just give you a lawyer.
You're on your own to find representation.
Exactly. And you can bet the landlord probably has a lawyer. Almost always.
Right. Which puts an unrepresented tenant at a huge disadvantage.
Absolutely. Having your own lawyer, especially one who specializes in tenant defense, like the folks at Martinez Law Center, levels that playing field. They handle court appearances, arguments, all the legal paperwork.
What if the tenant feels the eviction itself is just wrong?
Yeah.
Like there's no good reason for it.
That's another key time to get legal advice. California's Tenant Protection Act, the TPA, requires just cause for most evictions if you've lived there over a year.
Just cause meaning a valid reason, right? Like not paying rent or...
Yes, there's at fault, just cause things the tenant did wrong, and no fault, just cause, like the landlord wanting to move in themselves, which often involves relocation payments.
So if you think the landlord's reason isn't valid under the law, or they didn't follow the rules...
You absolutely have the right to challenge it. An eviction lawyer can analyze if just cause applies and build your defense if it doesn't seem legal or properly done.
Okay, what about situations like retaliation? Say you complained about repairs, and boom, eviction notice.
Definitely need a lawyer then. Retaliation is illegal. Evicting you for reporting code violations, safety issues, or calling 911 is against the law.
And discrimination too, I assume.
Yes, absolutely. Eviction based on race, religion, disability, gender, anything like that, completely illegal. A lawyer helps fight back against these wrongful evictions.
What if the place is just unlivable? Major repairs needed, landlords won't fix anything.
That can be a defense. Landlords have a duty. It's called the warranty of habitability to keep the property safe and livable.
So if they fail to do that, you might be able to fight the eviction.
Correct. If the conditions are bad enough and the landlord hasn't made necessary repairs after being notified, it can be a defense against eviction for, say, non-payment of rent in some cases. A lawyer helps document this and present it effectively.
And what about landlord harassment? Things like changing the locks or shutting off utilities.
Oh, that's completely illegal self-help eviction. Landlords cannot lock you out, turn off water or power, throw your stuff out, or intimidate you to make you leave without a court order.
That sounds terrifying. What should a tenant do?
Call a lawyer immediately. They can help stop it. And, in places like LA, you can also report lockouts or utility shutoffs to the police and file harassment complaints with the housing department.
It sounds like there are a lot of complex rules. Does a lawyer just help navigate all that complexity?
For sure. Eviction law isn't simple. You've got state law, the TPA, maybe local city ordinances too.
Right.
And there might be specific defenses, like maybe the notice wasn't served correctly, or the landlord accepted rent after the notice expired, or didn't pay required relocation money for a no-fault eviction. These often need legal expertise to even spot, let alone argue effectively.
Is it always about fighting in court? Can a lawyer help negotiate something?
Oh, absolutely. Sometimes the best outcome is a negotiated settlement, maybe a payment plan, or more time to move out, or what's called cash for keys, where the landlord pays you to leave by a certain date.
Oh, yeah.
An attorney can negotiate firmly on your behalf to try and reach a good agreement and avoid that formal eviction judgment hitting your record.
Which seems like a huge benefit. Just understanding the process must be a relief, too.
Definitely. It's confusing and stressful.
Yeah.
A lawyer clarifies your rights, explains the steps, helps you make informed choices, takes some weight off your shoulders.
So wrapping up, the consequences of an eviction are pretty severe, aren't they?
They really are. It's not just losing your home now. An eviction record can make it incredibly hard to rent again. It damages your credit and could even lead to wage garnishment. It has long-lasting effects.
So the main takeaway is, if you're a tenant in California facing any kind of eviction threat, get help and get it fast.
Yes, act immediately. That 5-day response deadline for a lawsuit is no joke. Don't wait.
Remember, you have rights, and there might be defenses you aren't aware of.
Exactly. And getting legal help, especially from tenant specialists, significantly improves your odds.
And there are resources. Look into court self-help centers, lawhelpca.org, county law libraries, and various legal aid organizations across California. Some cities even have right-to-counsel programs.
And don't tolerate illegal landlord actions. Get help to stop them.
So, again, for tenants in Orange County, Riverside, San Diego, or LA County needing help with unlawful detainer, check out Martinez Law Center. They only represent tenants. The website is martinezlawcenter.com.
Which brings us to a final thought. Given how serious and long-lasting the consequences of an eviction can be, isn't understanding your rights and getting expert legal advice perhaps the single most important step you can take to protect your housing future in California?
Call now 714-442-9741. Thank you.